Good afternoon. This is Maddie Heckman at IMN, and I'd like to thank you all for joining us today for our next session, What Hotel Owners, Servicers, and Lenders Need to Know for a Successful Receivership. We have a wonderful group of experts lined up, and I'd like to thank them all for joining us. Some housekeeping items I'd like to cover before we get started. Please feel free to use the Q&A button at the bottom of the screen. You can upvote questions from other people, and popular questions will be prioritized. While the Q&A is run through Zoom, you'll notice that the Hub platform is still open in your original browser tab. You can communicate with other attendees using the chat function in the Hub page for the session, while also listening to the discussion in Zoom in a second tab. Also in Hub, you'll see an evaluation section to evaluate the panel and leave comments on which other topics you would like discussed in this area. You must have the session added to your personal Hub schedule in order to evaluate it. Without further ado, I would like to hand things over to Michael Nanoski, who will be moderating this session. Thanks, Michael.
Thank you. Good afternoon, and welcome to the 125 session of what hotel owners, servicers, and lenders need to know for a successful receivership. My name is Mike Nanowski. I'm the president and a partner of Janus Hotels and Resorts. We are a Boca Raton-based hotel management company. We currently have 30 hotels with 7,000 guest rooms under management. We're owners, developers, third-party managers, as well as receivers in 75 cases over the past 25 years, and I'll be your moderator. We are very lucky to have a very distinguished panel of hospitality professionals today. Dan Lesser, President and CEO, LW Hospitality Advisors. Mary Jo Heston, United States Bankruptcy Judge for the Western District of Washington. Cliff Reisman, partner at Foley and Lardner, LLP, and Eileen Canta, CEO, AF Canta, Inc. The first question goes to Dan. Dan, what exactly are the qualifications of a hotel receiver?
Thank you, Mike, and greetings to everybody. I really appreciate the opportunity to join this panel. Just real quickly, LW Hospitality Advisors. We're a hotel-centric national hotel consulting advisory analytics family of firms. We basically have three silos of services: valuation, feasibility, market study, litigation support work is one silo. The next one is asset management, and within that is development consulting and advisory work. And then the third platform is analytics, lodging, analytics, research, and consulting. So interesting qualifications to be a receiver. So each jurisdiction has their own technicalities as to who can be a receiver. Some jurisdictions require that a named receiver be a citizen of the state. But generally speaking, it's somebody that is a disinterested party to the matter. It's as simple as that. Now, logically, you would think that a certain level of business acumen and understanding of the sector that the collateral is involved in, it would also be a requirement. But technically, it's not a requirement, right? So we're here on a hotel panel. If theoretically, and actually I've experienced this as of late, two different experiences. One was an individual being appointed or attempted to appoint as a receiver who had some business experience, but no hospitality or lodging experience whatsoever. And as I'm sure everybody on the call realizes, hotels are very complicated forms of commercial real estate. They're actually going business concerns that are married up with real estate. No credit tenancies whatsoever. The sale of heads and beds and food and beverage is very different, and controlling those expenses. So yeah, I mean, ideally you would want the qualifications to to include some level of expertise. Another recent experience that I encountered was all the parties selecting me to be a receiver, and I was nominated, and the court suggested that I would not be the ideal candidate. This court knew the perfect candidate who happened to be down the block. Um, who happened to be very good friends with the judge, who happened to run the judge's reelection campaign. And so I completely understood that that individual was much more qualified than I was, although that individual, again, had no hotel expertise whatsoever. So anyway, sorry, long-winded answer to your question, but thank you.
Yeah, I experienced the same thing. I think really probably New York would be the worst, and maybe Texas, but overall,
I didn't name any states.
Funny you should pick those two states.
Overall, I think the judge.
Come to Washington.
I think the judge looks at your experience and your background and your reputation. So I appreciate that. The second question, Mary Jo, what is the forecast for bankruptcy filing rates and receiverships for the rest of this year and into 2021?
Well, I think based on what we're seeing in the bankruptcy court, and by the way, prior to becoming a judge 3 years ago, I was a commercial litigator and with a focus on bankruptcy and receivership work in a regional law firm named Lane Powell up in the Northwest. And I did do mostly as debtor's counsel, a couple of hotel cases. So I do know that they have certainly the complexities that Dan indicated. But in answer to your question, Mike, I think based on what we're seeing, I think the types of cases that are going into bankruptcy or receivership right now are one of two types of cases. Either the types of cases, types of hotels that were in trouble prior to COVID, that were already in special assets or with a special servicer under the CMBS loans, or cases where I think the borrower has just given up, and handed the keys to the lender and just said, I'm through, I'm going to walk away, and doesn't want to be part of the solution. And so I think that I was actually listening to a program by CMBS special servicers the other day on the hotel industry, and they were saying their borrowers fall into three buckets. The bucket I just identified, the bucket where people are asking for short-term forbearance, which generally has been granted while the lender kind of grapples and gets up to speed and tries to bolster their kind of group of people that they're going to go to. And then there's a middle group of people, of hotels that have asked for a longer term forbearance agreement, and those are the ones that will probably be divided up again into work out with some sort of either new financing piece on the deal, or some sort of equity infusion by the owners, or some sort of partial liquidation. And then you'll have the parties that don't agree, and those will be divided up, I think, into receivership and bankruptcy. And I don't think we're going to start to see that, although it was interesting. There was a New York Times article this morning about the hotel industry, and they were saying out of the CMBS loans, which I understand to make up about 50% of the lending in the industry, that 23% of those CMBS loans are at least 30 days in default. And so I think when we get farther into the 60, 90, 120 day, once we get past that point, then you'll start to see an increase in both receivership and bankruptcy.
Just from our standpoint, since March, we've taken over 7 assets from special servicers as a receiver, and we probably have another 20 pending. So it's exactly what you said. if the property, I believe a lot of these assets were on the watch list pre-COVID. And as soon as we got into COVID, it was, just a waterfall event.
And I think the fact that the lenders have been given some relief from the regulators has helped, because they're not having to collateralize loans that were not in default pre-COVID, pre the March 15th date. But lender behavior drives a lot of, when you end up in a formal proceeding, as everyone on this panel knows.
Thanks, Mary Jo. Cliff, from a legal standpoint, what exactly is the servicer and lender's role in the process of getting a receiver actually appointed?
Okay, thank you. Thanks to everybody. Appreciate being here. I'm Cliff Rissman, and I chair the hospitality industry team at Foley. We work in the hotel space, the golf and club space, the restaurant space, and the timeshare and mixed use space, representing owners, lenders, financiers, and management companies. Of late, our practice has moved a lot more toward workouts and receiverships and the things we're talking about here today. Typically speaking, as Dan alluded to, the receivership is a process that is done through the courts. It is typically, it can be any creditor, but typically the lender that moves to have the receivership put in place. Normally that is pursuant to a provision in the applicable loan documents that enables the lender to take that action post-default. Many times it is with the acquiescence or cooperation of the borrower. Typically in the CMBS context, which was mentioned a moment ago, there are springing recourse guarantees, there are carve-out liabilities that would inure to a borrower if they endeavor to prevent the lender from exercising remedies or try to frustrate the lender's exercise of those remedies. And so consequently, the borrowers oftentimes acquiesce or join in the process. Dan Lesser talked a little bit a moment ago about the selection of the receiver, but it is typically the party suggested by the lender or the party that is having the receivership put in place. Once the court enters that order, determines the receiver is qualified, in most states the receiver has to take an oath, post a bond. Typically the bond can be minimal, but that process is not that cumbersome. The bigger process is post-appointment bonding and oath for the receiver to begin to get their arms around the asset, kind of figure out who's who, what's what, because until they are appointed post-bond and take oath, they normally don't have, there may be conversations, but they don't have access to the documents, the agreements, the financials, and it's kind of like someone opens up the fire hose and they start drinking once they're bonded and have taken their oath.
Understood. Dan, any thoughts?
Well, I think Cliff hit the nail on the head, and based on
Dan, you might be muted.
You're mute.
We send him a message.
Can you guys hear me?
Now we can. Now we can.
Oh, okay. Sorry about that.
That's all right.
Yeah, I think Cliff nailed it, and quite frankly, he also, Mike, I think he answered another question, which I think we had contemplated, and that is, what are the duties of a receiver, right? And
we're gonna come up to that question in a few more questions here, but I appreciate that very much. Eileen,
Mike,
sorry,
to
Joe, go
Cliff's
ahead.
point that the receiver doesn't have anything before getting appointed. In Washington, what they've done is they've combined the ABC, assignment for benefit of creditor, and receivership statutes, so that you can be appointed first as an ABC, the assignee, and be involved, and then subsequently appointed as a receiver. And what I've, in cooperative borrower situations, my experience with that process is that the borrower and the receiver can talk, with the lender and get things arranged before they're actually appointed as the receiver. Now, it's possible for somebody to challenge that appointment, but in my experience, it hasn't happened very often.
Very good. Eileen, good afternoon. During these tough times, how are the brands working with the owners and servicers and lenders as it relates to their franchise agreements?
Hi, everyone. Thanks again, Mike, for moderating this panel, and nice to meet everyone. Eileen Canta here. We've been in the hospitality space for 22 years, and we are currently working on our first hotel development ever. Kind of got delayed from the last downturn, but I'm not giving up. And we also are developing in a senior housing space, and we act as a third-party hotel fee developer. With that being said, I'm currently experiencing a situation where this project for a client of ours was in receivership, and the brand is not that flexible. I've spoken to Michael about this yesterday, and it's just been challenging. It's like pulling teeth. Instead of working with the new franchisee, it's not that easy. I had to call someone from the top in order for me to get a response from the sales guy, from the development guy that I've been dealing with for this area. And
well, the biggest problem that you're having is that 3/4 of the brand's team have been furloughed. So there's no one to call. So the first thing you have to do is get a hold of somebody, a real person, and they're all scrambling so badly that it's very tough to get a straight answer to it.
But unfortunately, fortunately, he's not furloughed. So for him not to be responsive was a little on the iffy side for me. And he kind of got a little pissed off that I had to reach out to the global head. And I'm like, listen, we have to all work together here. And you should be glad that you have a job. That's really what I said first and foremost. And my client here is working very hard to work with your brand and adhere to all the prerequisites that we have to meet. And we're spending about $20 million to keep the brand happy, right? But no buts or ifs about it. They don't want to work with us. They don't want to extend anything, extend even the franchise agreement, let's say to 20 years. They don't want any of that. It's just kind of bizarre in my
experience with that in the past has been, if it's a great location, if it's a great market and a great location,
yes.
If your property is older, and in the case, I think you and I talked, your property was 30 years old.
Yes.
I mean, the brand may have somebody ready to build a brand new, shiny, property right there in that marketplace. That'd be number one. Or number two is if there has been a history of poor scores with the brand, they're not very likely to work closely with you.
But they've never my client had never dealt with this particular brand that I mentioned to you. So it's just a little, it's just, to me, it's a bit sad that a brand would be tough to deal with during these times.
Yeah. I mean, in most cases, Dan, you could help me here too. I mean, the brands have extended the PIPs 9 to 12 months. So from a property improvement standpoint, unless it's a life safety issue, you've been given, 12 months of a forbearance to go to the PIP. I have not seen any reductions in fees or modifications to the fees. And it's very difficult to get a hold of a lot of the people that used to work with you at the brand because a lot of them are furloughed. So I think you have to keep going up the food chain until you get a hold of somebody that can actually make a decision.
And that's what I've done. And also to add to this, it's hard to get a hold if it's the properties in receivership. I'm having challenges getting a hold of the documents, all the files. The last downturn, I've been involved in taking over properties, but all the documents were there. I think this time around is a bit different. Previous owners are a little bit more on kind of like upset. I'm trying to be I'm trying to be polite as possible, but they're not as easy to deal with. So what they did is they erased all the history, and I have to go through everyone involved, and the banks doesn't have anything to give you either. So it's just really been challenging in order. Basically, you're starting from scratch in my experience. And
sounds like you may need a good lawyer.
A good management company, right? That's it.
And right, and you got two excellent ones right on the line. They don't pay you, by the way.
So here's your question, Dan, which is the meat and potatoes of our whole program here. What exactly are the duties of a receiver?
Well, thank you. And Cliff was alluding to it earlier in his response. I mean, you know, at the end of the day, a receiver is an agent of the court, and a receiver is a fiduciary who steps into the shoes of acting like an owner and being responsible like an owner. And the key fundamental concept of receivership is taking control of an asset and securing it, and securing the value of the asset at a minimum, right? Hopefully there's opportunity to actually increase the value of the asset, but definitely avoid asset value erosion. And you know, it's basically asset management on steroids is what it is. And then stabilizing the asset and getting it to a point where, you know, an economic decision is ultimately made as to, okay, what happens now? You know, does the asset get sold? You know, what exactly, you know, what's the exit strategy on behalf of the lender?
Right. You know, just from a granular standpoint, from a management company, you know, the servicer and the court is looking for you to take control of the asset, protect the asset, make sure that the bank accounts are changed and credit cards are changed, make sure the employees are okay and that they know that they have a job and that they're comfortable with that. Make sure there are no life safety issues with the property. That's first and foremost. Again, if the property was in the middle of a PIP, you could really just stand down the PIP and put it off for another, you know, 9 to 12 months. But anything that would be life safety has to be taken care of right away. And then most importantly is build revenue. Open up all the revenue channels so that you can get cash in the bank so that the servicer lender does not have to fund it, you know, hopefully going forward from that standpoint.
Agree 100%. And obviously it's very important for the receiver and the day-to-day manager, the management company, to have a good working relationship. I mean, that obviously is key here.
No question. They're partners in the thing, and obviously they're both looking out for the benefits of both sides, and most importantly, preserve the asset and hopefully get enough revenues in to make it, you know, function, continue to move forward.
Agreed.
Mary Jo, what are some of the differences and issues likely to be encountered in Chapter 11 cases pre-COVID and post-COVID?
So I think the biggest issue that if you end up in a bankruptcy, and I think there's going to be more interaction between receivership and bankruptcy given kind of the low values that we have right now. By that I mean, you know, you might have a situation where the lenders who generally, in my experience, prefer a receivership for the fact that it's less costly and usually quicker, and they have a lot more control and no creditors committee that's coming back and counterbalancing the things that the lender wants to do. But I think because we're in a very low trough in terms of valuation, that is going to be, and we've the front and center issue oftentimes in any kind of hotel bankruptcy in this environment. And the reason for that is because one of the reasons that borrowers like bankruptcy is that they can cram down the amount of the secured creditors, the bank's lien, to the value of the collateral that existed on the date that they filed their bankruptcy. And there are some counter moves that a lender can make to counteract that. But for example, since we're in a trough right now for the value because of revenue streams being so low, it would be an advantageous time for a borrower to file bankruptcy. Of course, that assumes that they have some ability to cash flow. And, that's driven by both their current cash flow ability to use what we call cash collateral, which is basically the hotel revenue, rents, and the like, to pay their operating expenses, which I suspect many current hotels don't have that capability given the vacancy rates and the rates that they're experiencing. But if they have new money coming in, maybe they have the ability to liquidate some assets, or the owners have some money, or there's a new lender, then what I would expect to see is maybe some priority fights as well. And there's an interesting provision in the bankruptcy code that I've looked at. I've never seen anybody raise it. But in 1994, they clarified that rents are part of lender's collateral that's properly secured in those rents. But there's a provision that allows the court to, basically it says that the rents or the hotel revenue, the payments by the hotel guests, for example, is part of the lender's collateral. But there's a provision that says that it's part of the collateral except to the extent that the court, after notice and a hearing and based on the equity of the case, orders otherwise. And I don't know exactly what that means, but I have seen some rather creative arguments by borrowers in this current COVID environment, and wouldn't put it past somebody raising that in terms of the ability to use rents. The other issues that I think will come up are the ones that Eileen mentioned, which are franchise issues. Bankruptcy, does give you a breathing room in terms of those agreements to a certain extent, although the franchisor can come in and seek to force you to a decision to assume or reject those contracts. But in my experience in the hotel cases I did, we were able to hold the franchisor off for a long time just by virtue of the way that the bankruptcy code works with regard to executory contracts.
Thanks,
Ultimately you have to pay the piper, obviously, and deal with it and assume the contracts, but it will buy you some breathing room. And I assume receivers can, in some states, I know in Washington, there's the ability to deal with contracts under the receivership statute. But,
so Cliff, this goes to you. In light of what we were just talking about, what receivership issues are unique to hotels relating to the franchises and the franchisors?
Well, look, it was alluded to earlier that hotels are a very different animal because it combines a complex operating business with traditional bricks and sticks real estate. And so franchise issues, management issues with branded managers. I want to talk for a second about liquor, about employees. It's just a different animal. And, you know, there was a conversation before, Eileen mentioned difficulty in getting a hold of the brand. It's been really interesting lately how the different brands have reacted to these situations. And whether it's part of a master plan within a brand or whether it depends who answers the phone, I don't know. But we have experienced everything from one major brand essentially wanting to repaper the franchise agreements, gin up new fees, cut off access to third-party managers who haven't signed, new managers coming in who haven't signed manager consent forms, and literally just almost make it as difficult as possible for the receiver to maintain the status quo. At the other end of the spectrum, we've seen brands who, if the check keeps showing up every month, don't call, don't write, and don't even want to talk to you. And there's been really no rhyme or reason to it, but there's the franchise issues there. Y'all talked about PIPs, the management company issues. Layer on top of that, liquor licenses oftentimes were with an outgoing manager. Some states they can be transferred, other states they can't. The new manager or the owner has to reapply. Sometimes you need to use the outgoing manager's license for a period of time while that process plays out. If they're being cooperative, if they were affiliated with the owner whose asset has gone into receivership, that can be an easier process. If not, it can be a more difficult and time-consuming process. All these issues fit together because you may be in breach of your agreement with the brand, your franchise agreement, if you go through a gap period where you cannot sell alcohol. You've got employment issues with layoffs, furloughs, WARN issues, WARN notices properly given. Is there potential WARN liability? More importantly, in jurisdictions where there is significant organized labor, if there's a collective bargaining agreement in place, is the receiver stepping into that agreement in terms of potential liabilities such as unfunded pension plans? If there are accretion provisions in those CBAs, and I don't want to get down in the weeds, is a receiver or a new manager who's coming in and being asked to sign on to that collective bargaining agreement going to have accretion issues with other properties they manage? Are they stepping into that unfunded liability? There are issues with credit cards. The vast majority of the revenue in most hotels comes through credit card transactions. Moving those credit card accounts, because that's how the revenue is coming into the hotel operating account to pay bills, etc. There are a myriad of issues, but I probably used up more than my allotted time already.
No, you were spot on. And, just for example, the credit card issues, with the Patriot Act and everything that's going on, it used to be fairly simple to get a new merchant number and start the processing over again. It takes weeks now. Everything has been, a roadblock has been thrown in the way. So it really is. As it relates to the franchises, though, I think everybody should take a step back and not do anything. They don't know what they're going to do. The last thing, first of all, they're in no position to renegotiate anything. The only thing they're allowed to do is give you some time on the PIP. So my recommendation to my customer is be patient. Don't do anything, because we're not sure where this thing's going. We really aren't.
Well, I think that's right. And absent situations where you have a very tired asset that is clearly not going to be renovated, the investment's not going to be made, and the brand wants out, or where they've got another developer wanting to put another one newer down the street, you're absolutely right. They want to continue their revenue stream. And everybody was, when all this started in January, February, I heard the term a lot, playing nice in the sandbox. everybody seemed to be for a while, but I think people are tiring of some of those niceties. I think most of the brands, just like the hotel owners, they're in trouble. They've seen a loss of revenue. They've laid people off. Their mantra is cash in, no cash out. So at the end of the day, generally speaking, if you'll continue to pay their fees, they should want to work with you. And their one overriding concern is not to be out of pocket cash. For example, they'll dig their heels in on having you pay their legal fees for whatever has to be done, renegotiated, papered, because they don't want to write a check even to their lawyers. That is their one mantra: conserve cash out the door.
Thanks, Cliff. Here's a question from the audience. When you take a hotel back in receivership, are you looking to stabilize the hotel and keep it a hotel, or are you finding alternative uses for a hotel? Dan, your thoughts on that?
I mean, that's a really good question. If you go back to the premise of, taking control of an asset and yes, stabilizing it, I'm not sure that it's a receiver's responsibility, and frankly, the qualifications of a receiver to go through the process of reorienting the property to an alternative use, right? I can't say I've run across that just yet. No.
I agree, and I think that anybody that has a solution for an alternative, a really easy, good alternative use, is going to make a lot of money. But you know what? It's been very difficult, for the last 30, 40 years. I mean, how many true conversions to an alternative use have you really seen that have worked? I mean, they're few and far between. If somebody figures it out, they're going to make a lot of money. I want to finish the group with this question. What do you see as a general overall hotel climate after COVID? Can we just get some thoughts on where you see the climate?
That's a big assumption, after COVID.
Right. Meaning, how is the hotel climate now that COVID is here?
Right. But the reason I brought that up is there's no guarantees that COVID ultimately goes away. I mean, we may very well have to learn how to live with it. Anyway, I just wanted to clarify that, because that's a big if, right?
It's a big if.
Listen, the industry, went from all-time high revenue generation, profit generation, for quite a period of time, and then in call it 26 weeks, the industry has been set back, 26 years. Right. I mean, more than that. The economics are unprecedented as to what's going on in the sector. Now, it is interesting. There is a bounce back that's occurring on the one hand, and but on the other hand, and today people talk about, oh yeah, well, RevPAR now is only down 50%, 50. That's like a beautiful thing today, right? As opposed to 90% just a couple of weeks ago.
It took us 30 years to finally get the RevPAR to where we can make money.
Yeah, and Michael, I think there's two other things I'd add real quick. One is, I don't think you can view the hotel or the hospitality industry as a whole when you try and answer the question you just posed to Dan. Because, for example, if you're talking about large convention center hotels, meeting-oriented hotels, I'm a lawyer. I don't do what Dan does, but the timeline for that to come back to where it was is likely very, very different than limited service hotels and more transient hotels. And the other thing that I think, and everybody tends to focus on the financial, from an operational perspective, if and when you get to post-COVID, will things ever go back to where they were, or will some hotels no longer have 3-meal restaurants and you'll be expected to have your grab and go breakfast? Or are they not going to start coming into your room again every day and changing the sheets? Or will the cleaning standards go back to where they were? Or will restaurants ever have buffets and salad bars? I mean, pick an issue, but I don't know when or if they ever go back to where they were.
Well, I think it's going to have to reinvent itself. I was in Connecticut, and I walked through 3 of the big boxes, all top tier brands. You could shoot a cannon off. The meeting space was completely dark. All the convention space, completely dark. Everything shut down in the business. And I'll tell you, that is scary. I would not want to have a handful of those properties to deal with. At least from a select service standpoint, I could scale it back to 6 or 7 employees, keep it open, and maintain going forward. We've seen a 60 to 70% drop in revenues. We've also seen that if it's a extended stay hotel, they seem to be doing better in this environment because they're getting the blue collar drive worker that has to work. If you're dealing with the need for airlift or the white collar corporate traveler, they don't exist. So it's going to be crazy.
Go ahead, Eileen.
Oh, no, I wanted to add to that, Michael. I think Americans will drive for the rest of maybe, the next 3 years. And because I've experienced driving through places that I've never been to before because I couldn't fly. And I kid you not, the resort and destination hotels are full and they're charging so much money. It's crazy. It's Telluride Colorado was charging $600 a night for like a no brand hotel. Okay. And in Jackson Hole, Wyoming, they were charging $675 for a Homewood Suites. I mean, do the math. So I think there's going to be a change on how people will book hotels in that sense. And I've experienced it myself. So select service will definitely do well, and extended stay and the drive-through hotels and the resorts will do well.
Mike, I'd like to just, at the right basis, I actually like big box hotels today. If you may recall 20 some odd years ago during a downturn, the LAX Hilton at the Los Angeles airport traded, I believe that's a 1,500 room hotel. It traded for $10,000 per room. That's a lot of real estate for $10,000 a room. So, like any investment, right, it's all about your basis. And I actually like long-term prospects for big box, but at the right basis.
Yeah, and the question is, what is convention business going to look like next year and 3 years from now? I got to believe it's going to be changed. I got to believe it's going to be smaller. So I would not want to have 500 rooms with 40,000 square feet of meeting space and want to know how I'm going to fill that again. That would really.
But if you pay a low enough price, you can afford the cash burn. And frankly, big box, if you're not underwriting an assumed holding period of at least 10 years, you probably shouldn't bother, right? You have to be ready to hold it for at least 10 years. Doesn't mean that if a capital event opportunity comes up beforehand that you won't take advantage of it. But I think there's going to be some real money made in the big box arena at this juncture.
I think you might be right, but I'll tell you, in the last 90 days, the one thing I haven't seen is anything sell, because no one knows what it's worth. And that is the key to these opportunities that you're talking about. If you can get a big box at that kind of a discount, that's great. But the question becomes, how does it get that low? Listen, we have to wrap up. This was a terrific session. I thank all of you professionals for being part of it. I would advise anyone that's listening to take advantage of these hotel professionals. All of their emails are available to you. If you have any questions for Cliff or Ann or Dan or Mary Jo, please send the email out and they'll be more than happy to respond.
Thank you, Michael. Thank you all so much for joining. I really hope everyone found the discussion to be of value. I'd like to express my gratitude to Michael Nanoski, Eileen Canta, Cliff Risman, Daniel Lesser, and Mary Jo Heston for their time and expertise. We'll now have 2 concurrent sessions that will be starting in 15 minutes. The first session is hotel valuation in a distress cycle, and the other session will be de-stressing through strategic transformation, a focus on operational strategy, cash management, and asset preservation. And both of these sessions can be accessed on the schedule builder in Hub once you've left this Zoom webinar. In the meantime, thank you all so much for being here, and we look forward to seeing you again soon.